go-to resource for U.S. immigration insights. We provide clear immigration news and information. Our platform provides a network of licensed attorneys who can answer your questions and guide you through the process. From visas to green cards, asylums to citizenships, immigrationquestion.com helps you to network with immigration attorneys so that you can move forward with confidence. Sign up today or download the app. Free registration, limited time offer. Stay tuned. We go live in 30 seconds.
Hello, everyone, and welcome to today's live webinar brought to you by immigrationquestion.com, a networking platform and meeting ground where immigrants, families, advocates, and licensed immigration attorneys come together to learn, exchange information, and stay current on U.S. immigration developments. My name is Nikola Ristic, and I'll be your host for today's session, From Entry to Approval, Step-by-Step Guide to Filing an Asylum Case. Filing an asylum case in the United States is a high-stakes process where timing, credibility, and documentation matter at every stage. From the moment of entry into the U.S. to the final decision, even minor missteps can lead to delays, denials, or referral to immigration court. Understanding how the asylum process works from start to finish is essential for anyone navigating this path. Today's discussion is designed to walk asylum seekers, advocates, and supporters through each phase of the asylum process, clarify what adjudicators look for, and highlight how applicants can prepare strong, well-supported claims in today's increasingly strict adjudication environment. To guide us through this important topic, we're joined by attorney Sonu Lal, an experienced business immigration attorney dedicated to helping employers secure work visas and green cards for skilled professionals. He specializes in H-1B, L-1, E-2, and EB cases across diverse industries, including technology, finance, and hospitality. As a graduate of Cardozo School of Law, Sonu is licensed to practice in New York and is an active member of the American Immigration Lawyers Association. Attorney Lal, thanks so much for joining us today.
Thanks for having me.
Before we begin, a quick note for everyone tuning in. immigrationquestion.com is a public platform created for education and discussion. Attorneys who participate do so independently, and the platform does not provide individualized guidance. To everyone joining us from Facebook, YouTube, LinkedIn, and other platforms, welcome. If you haven't subscribed yet, now's a great time. Grab your notebooks and let's get after it. Attorney Lal, at the very beginning of an asylum case, what factors related to entry into the U.S. most strongly shape how an application should be approached?
It's a very good question. At the beginning, you have to decide which government body has a jurisdiction. Sometimes we see people in the U.S., they file their asylum application with the incorrect authority. So the system works like this way. If you are in the immigration court proceedings, then the EOIR, the Executive Office of Immigration Review, meaning the immigration court, has a jurisdiction. So your asylum application should be filed with immigration court. On the other hand, if you are not in the court system, if you came here on a visa and you are in the US, you decided to file asylum, then you will be filing your asylum application with USCIS, not with the court. This is the most common mistake that we see in our office too. When people come to us, they've already filed their asylum application, but with the wrong authority. So that's a very initial question that they have to decide. Where should they be filing their asylum application?
Now, the one-year filing deadline is a significant concern for many applicants. How should individuals assess whether they meet this deadline, and what situations most often create confusion or risk?
It's very, very important that if you are filing your asylum application, it should be filed within 1 year of your arrival. If you have not filed your asylum application within 1 year of 1 year deadline, it's not likely to get approved. Only in exceptional circumstances where your case falls into one of these very limited exceptions. For example, you were sick during that time and you could not file it. Or there may be some other extraordinary circumstances. Otherwise, your asylum application cannot be approved. Be it USCIS, be it immigration court, it will not be approved. So it's very, very important you file an asylum application within 1 year.
Now, when preparing an asylum application, what types of evidence tend to be most influential in establishing credibility and consistency from the start?
So very good, very relevant question. So the type of documents would depend upon your basis of your asylum. For example, if you are claiming political asylum, you are saying that I was a member of political party A in my country and I was persecuted because of my political opinion. What you would provide is, in terms of documents, you would provide proof that you are a member of that particular party that you are saying. You can also provide proof in terms of affidavits of letter of support from people who are familiar with your case. In any case, if you were injured or you were persecuted, and if you reported to the police, you can provide the police reports. And if you were physically injured and you went to hospital or doctor, you can provide doctors. These are the common documents that you can provide, but these kind of documents would differ on case-by-case basis.
Absolutely. Now, as cases move forward, how does the asylum interview or court process typically unfold, and what should applicants understand about how their testimony is evaluated over time?
So there are two things in this. Let's say your asylum application is with USCIS, then you will be scheduled for an interview with an asylum officer. If your case is in immigration court, you will be scheduled what is called a merits hearing or an individual hearing. Either ways, be prepared to answer whatever you are stating in your asylum application on your form 589 or your accompanying statement. Either the judge or the asylum officer will be asking a lot of questions based on whatever you are stating in your asylum application. For example, why you cannot go back to your country? Who are the people who are threatening you? Why you cannot resettle in another part of your country? These are the very common questions that you will be answering either at your asylum interview or at your merits hearing in the immigration court.
Now, we both know that delays are common in asylum cases. What are the most frequent reasons cases stall after filing, and how should applicants manage extended waiting periods?
So we, in our office, what we have seen for USCIS, some cases are being scheduled for an interview very soon, maybe 6 months to 8 months. But we have seen few cases, they remain pending for 3, 4, 5 years and have not been scheduled for an interview. When it comes to immigration court, it may depend state to state. For example, New York City immigration court at this time, if I'm appearing for a master hearing and requesting an individual hearing, from most judges at this time, the date I'm getting for an individual hearing is somewhere in 2028 or 2029. The reason why there's a long wait for these dates, maybe the docket is too long, maybe there are a lot of applications which are pending.
And for individuals early in the asylum process, what practical steps can help strengthen a case as it moves from filing towards a final decision?
So let's say you have submitted your asylum application and it's either pending with USCIS or with immigration court. Even before the interview or the individual hearing, you can still submit additional documents. We have seen sometimes when you're filing your asylum application, at the time of filing, you may not have sufficient documents to prove your case, but you can gather all those documents later on and still submit it either before the individual hearing date or before your asylum interview.
Great. Thanks for those insights. It's been an interesting session so far. For everyone watching live, L1 petitions require careful planning, strong documentation, and ongoing compliance. Staying informed about adjudication trends and expectations can make a meaningful difference in how these cases are reviewed. Another question for you, Attorney Lal. For individuals early in the asylum process who may feel pressure to file quickly or proceed without complete preparation, what warning signs should prompt them to pause and reassess their approach before moving forward?
So they have to make sure that they are filing a strong immigration, meaning asylum application. What it means is they are submitting supporting documents, whatever they are stating or whatever are the basis of their asylum that they are claiming. For example, if in your statement you are saying that I was physically hurt by these individuals, and in that case, you should be submitting some kind of doctor's report. Or if you reported that incident to the police or law enforcement, you should be submitting those kind of police reports. If you are not submitting these corroborating documents, the asylum officer or the immigration judge is less likely to find you as a credible witness and not likely to approve your asylum application.
Amazing. Thanks so much for that insight. I got a question for you about some of the recent news that's been going on. Recent reporting has highlighted cases involving individuals who were deported to Ghana and later returned to countries they feared. Attorney Lal, how should people following asylum developments interpret situations like this, and what does it reveal about the risks involved when asylum claims are not thoroughly examined?
So recently what's happening is, in the immigration court, typically, what the government is doing, they are raising this ACA Asylum Cooperation Agreement with few countries, such as Uganda, Ecuador, etc. For example, if you are from some African countries, and what the government is doing is they're filing this motion to preterm it based on this Asylum Cooperation Agreement. What they are saying is, let's say you cannot go back to your own country, but since the government has the Asylum Cooperation Agreement with countries such as Uganda, we can still send you to Uganda. And they are filing this, what is called motion to preterm it, meaning without having an individual hearing, the case may be dismissed. So if you are in immigration court proceedings, you do not have an attorney, I highly recommend hire an attorney, because on your own, it will be very tough to deal with this or to navigate this immigration process.
And one last question for you here, Attorney Lal. Based on your experience, how do platforms like immigrationquestion.com help immigrants and immigration attorneys like yourself?
I think it's a great platform because it connects the attorneys and the client, or people who are looking for attorneys, connects both the individuals. So it's kind of win-win for both the parties.
Great. Thank you for that insight. We love to hear that both immigrants and immigration attorneys get value from our platform. Thank you so much, Attorney Sona Lal, for sharing your time and insight today. Your explanation of the asylum process helps clarify a system that can feel overwhelming and uncertain. To everyone watching, thanks for joining today's webinar. We hope this discussion helps you better understand how asylum cases move from entry to final decision and why preparation at every stage matters. You can always visit immigrationquestion.com to ask immigration-related questions and stay informed about upcoming discussions. If you'd like to revisit today's session or share it with others, the full replay will be available on Spotify soon. Just search Borderless Talk by immigrationquestion.com. Join us again on Friday for another live conversation covering key immigration topics and current developments. Until then, stay informed and stay connected.